So, welcome to Chandra Charisse, that would be me, trademark, patent, and copyrights, with, of course, a focus on trademark basics. Something that you should know is this isn't just something that I just happen to fall into. I have a very diverse background. My first trademark was for my entertainment company, which you see listed here, Livewire 99 Entertainment. And I'll get into some of the things that I learned about it a little more within the course about trademarking that particular company and why I changed what I did with that company. You'll also see that my background shows you that I have tech background, nonprofit. I've even worked in PR for a bit. I still do government contracting under my company. And yes, I did fashion merchandising. I was one of those lucky people out of college that got to work from home. On top of that, while I had these day jobs, I ran a whole entertainment company, which you see listed, which included live events. Sometimes I'd have to travel on the weekends and be gone. And all of that actually started during my years in college, where I was planning all the concerts, festivals, and tours that came there. And from that, I got connected with people in the music industry who wanted me to travel with them to do some more tours and things, but I wasn't trying to have my parents kill me for quitting school. Hindsight, people quit school all the time now and go on to do stuff, but I was going to have them kill me and not get this degree and travel all over the place. And then I currently and still do operate and own a travel company under the Livewire umbrella, which is blackwilltravel.com, but just Black Will Travel. So when you see that or I reference something about travel, that's because I have agents that train under me and they run their own business, and I'm well versed in that and did it as an extension of Livewire Entertainment in order to provide travel for conferences, as well as the event designs and award shows and all that good stuff. So all of this tumbles into each other and you get Chandra Charisse, your intuitive business strategist and life coach, because my life lessons help me develop strategies in order to help people grow themselves and their businesses. Now, just because people like social proof about the quality of work, one of the people that I had the pleasure of working with would be Mary Chapman with blackbride.com. If you're not familiar, you can go take a look. She's very prominent and well known throughout the years. She's grown her platform, and I was there when she acquired the company, and she happened to have a fashion show going, and I just made sure that she had everything that she needed while she was doing her show in terms of floral design. See, I tell y'all, I do everything. so I would have never thought that in 2005, when I was trying to do my own trademark, that I would be teaching a class on it now. But again, there are things in your life and a process that happens, and you're like just trying to figure it out. At the time, I thought it was super expensive because that's the first thing people think. And then I thought it was difficult, but it never hit me that maybe I need a lawyer to do this like it does now. Most people, they get scared and intimidated and they go, I need a lawyer. Even during that time, the process wasn't as streamlined as it is now via the United States Patent and Trademark Office, which you'll hear me refer to as USPTO during this presentation. But just know that it's a lot easier now than it was then. And I learned many things. I had to answer actions, which now people get nervous about. And again, this is why they may hire a lawyer. I had to respond to different things that they asked me about for clarification. But the most important thing that I learned at that time was they are there to help you, and that hotline that they have that you call, that's not just a general hotline. They will assist you through the process, which helped me to be more comfortable and more well-versed in it. On the screenshot, you'll see that it's canceled now because when I hit the 10-year mark and I transitioned my business, I decided that I no longer wanted to keep the mark because I wasn't using it in the way that I originally registered it. And I didn't want to add any other definitions to it, which we call classes, simply because I was changing my business model as a whole. Does that mean that I cannot use it in public or it's not protected still? No. It just means that I'm using it now, but I'm not using it in the terms of managing models, et cetera, et cetera. Now, do I currently under Chandra Charisse, which is actually a separate entity? Do I have models and stuff that I work with? Absolutely, I do, but it's not in the same capacity. So I'm hoping as an entrepreneur, I'm able to give you a different perspective and a better understanding than you would generally get if you ask someone how to do this or if you do speak to a lawyer. But please understand, I am not a lawyer. This is not legal advice. This is just simply instruction to help guide you with what I learned through taking classes and studying with USPTO and to be able to do this stuff for myself when I didn't have any help. So the basics, I was lucky because my degree is in marketing and my business school focused on these type of things. I had an understanding of trademarks before I even went into the process of trademarking. But for the purpose of this, let me help you understand the difference. Some people assume that they know the difference and it may not be what they think it is. So if you are able to, make sure you take notes and pay attention, because these little snippets will help you stay on track when you're deciding if you're going to do this yourself. And then when you do this yourself, how you plan to execute this. So trademarks, identify your brands for goods and services. Now, people don't look at themselves as a brand necessarily. They'll say that they have just this good or they just sell this thing. But also, since I work with creators and influencers, they don't look at themselves as being particularly a brand or a service brand, but they are a service brand. They provide entertainment. So for them, it is imperative, especially in today's age of copycat culture and popcorn wanting it now, that they protect themselves. So when I'm working with them, we speak about what service it is that they provide, if they're trying to protect their YouTube channel, things of that nature, and how we need to go about and do that. So make sure you define what you do. What are you selling? What service are you providing? And define it to the umpteenth power, and define where are you providing it. That's very important for you to do. Once you have those things answered, when you decide to go through the process, or if you decide to go through the process, it'll be a little bit easier for you. Now, what people aren't familiar with is that it can be a word, a symbol, a slogan, or a sound. I didn't list that on here because sounds are a little bit more difficult to trademark. And an example of that would be the "you've got mail" sound from AOL, or if you heard the Lionsgate sound of the lion roaring for the movies. I mention those all the time when I teach this, because those are the things people are familiar with hearing. And one of the first trademark sounds was that roar. So, and that was done in, I believe, in the 50s, if I'm correct, for it to be done. Yeah, to have a sound done. So that, if you're doing a sound, I suggest that this would be a time when you need a lawyer to help you do the sounds, because sounds are just a little bit more difficult to do, but it still uniquely identifies who that company is. Just from me saying those words, I'm sure many of you were like, oh yeah, I know what that goes to. That's AOL. Oh yeah, I know what that goes to. I've seen that in the movies. They used to do it all the time in the black and whites, and even now they do it at the end of the movies that you watch. So it's quite interesting. Your patents. Patents, I'm not well versed in. However, I do have a young lady that I'm working with who has done several patents, some with lawyers, some herself, and we're getting ready to discuss if we are going to teach this patent class so that I can have her on the platform, because I think people get a little nervous about it and they are more complex. That is something that, depending on what it is that you're doing, that you may require a lawyer, hands down. However, she was able to do it with both. She started off with a lawyer and then did it herself. So that being said, patents protect an invention. Some people think that they can patent, like, let's say they have a house design and they're like, this is a special house design and I could just patent this. No, it doesn't protect an idea. Your invention needs to be able to do something that either processes something different, creates machinery or some sort of tool to change something, or scientifically it changes the composition of something. In this case, the reference that I have for you is Rochelle Ingram from YS Sweets or YSC Connections. If you go look her up on YouTube, she's a YouTuber baker. And I recently did this class for her as well. And she has patented a recipe. She calls it the 411 recipe. And what it is, it's a certain type of recipe that she has that goes with her candy apples that she does. Now, she was able to prove that she scientifically changed something and made it better in order to get the patent. And that is something that people need to do for recipes if you so choose to do so. But in doing that, you also open, when you patent something, it up for other people to view it and then alter it to their needs or whatever they have that they can show that's different from yours. So just be aware that when you patent anything, and even when you copyright, when I move over to that, that information will be known to the public. So this is also why you will note that Coca-Cola has not copywritten and or patented their recipe for Coke, because they don't want everybody to know what's in it. And they've been able to keep it secret for years, and still no one else is able to duplicate it. However, in her case, she wanted it to be open to everybody else because she understood how it could benefit other people and would help people grow their businesses. So she did that. I believe she may hold another patent, but I'm unaware of what that patent is. I'll have to ask her for the next time. Then there's copyrights. Okay, so there are now new options for being able to copyright. This too, you can use to copyright something that you've written out, but remember, if you're doing something like a new process, if you have a new rental process for a home and you're like, I need to protect that idea, this is not the way to do it. Copyrights will still make it available so that everybody else can view it. And they typically last for about 75 years post the death of the person who created it. So if you don't have your family continuing to renew it, then you will lose that right to it just yourself. However, it will be put in the Library of Congress. And let me say, this is just for those people in the US who are watching this. It will be put in the US Library of Congress for people to be able to view and share and learn from and reprint. You see this a lot when you're looking at books from university professors who got grants to do some sort of research and then they've passed on, but the schools have been able to reprint their work. This is why. Now, what has been introduced lately is being able to batch your copyrights for your social media posts. So if you want to have like Instagram posts that you design, let's say on Canva, and for those of you all that don't know what Canva is like your easier way of having Photoshop in your hand now, because they've changed so much over the years, but you can do this for free and edit your look and feel, build your brand colors, all of that stuff. So if you have a bunch of Canva posts and you're putting quotes up that you did yourself and you don't want anybody to have access to that, they now have bulk copywriting. Before it used to be per thing that you were doing. And now it's like, I believe it's $65. Don't quote me on that because it may change, but it's $65 and it allows you to do a bulk for up to, I believe, 100 things at one time. Now, in my case, I have a copyright for the logo for my travel company, Black Will Travel. And the reason I did that is because I wanted the individual that I hired to be able to get some sort of recognition for it. And also I wanted to protect the look and feel of it. Now, where people get confused is sometimes the protection of that look and feel can also be done with a trademark, depending on what it is that you want. However, it is usually more safe if you do the copyright for the image and do the trademark for the words. So that is a little extra tidbit. I'm giving this to you. Usually I do this with the advanced when I'm doing the group that I'll introduce to you at the end, where I talk about that a little bit more. So in my case, we had Black Will Travel. She worked really hard on that logo for me. I wanted to make sure it was copywritten. And so I went and submitted the information. Again, like I spoke to you about in the beginning, there's someone there to answer your questions and to help you. All you have to do is ask. So in my case, because this is some work for hire and I didn't design it myself, I'd put incorrectly on the form that they worked for me. And then I put a note that was like, I actually hired them such and such and such and such. Well, thanks to email, they didn't have to give me a phone call. They emailed me back right away. I was already assigned someone, and this individual said, hey, uh, do you mean that you hired this person? There's a different way to list them if you hired them, but it's still your work because you paid for the work. And I said, yes. They said, well, correct this part here and do this, and then we'll submit it. I did that, and I had my copyright done in like 3 or 4 days. By the end of the week, it was done. It didn't take but a second, and I paid $50 at the time. So keep in mind that you don't have to go through a bunch of hoops. And if you have any questions, that you have the help that you need to do it. Now, something that's interesting, which I'm going to go back to why I let the trademark go for my company, Livewire 99 Entertainment. Because at the time when I did it, I was having a bunch of competition. Everybody was downloading music, torrenting music. It was Livewire, LimeWire. There were people with entertainment companies that were like Livewire over and over again, right? And I was like, the only thing I have like exclusive rights to that shows that I'm different from everyone else, outside of the fact that I have Livewire combined instead of separate, is the number 99 in the middle. But if I'm going to chase people that are doing the same thing, how is that going to work for me? It's not. So because that wasn't going to work, when I hit the 10-year mark, it was like, do I want to pay to keep this going? And that's something else that people are misinformed about. Every 10 years, you have to show that you're still using your mark in commerce, and then you have to pay a set amount of money depending on the number of classes or categories that you have assigned to your mark. At the beginning of this presentation, you saw that I had one category or class that I actually paid extra for to define it myself, because they didn't have a definition like that when I did it. Now, what's funny is since I paid the extra to do it, that definition now exists in the standard trademarking manual. So because of that, it was $500, and it still is now. So this may change by the time that you view this or when you go back, but just know you can find all of this information still on the uspto.gov site. It was $500 every 10 years per class. So if I would have registered under 2 different classes or categories, then I would have been paying $1,000 at the 10-year mark. So make sure when you're using your brand, you're saving for that, and any monies that you get, you keep it if you don't already have it there, because you know that this renewal is coming up. And also make sure that you have proof that you're still using it in commerce. Now, again, the only thing I had rights to that made it different really was 99. I didn't have exclusive rights for the definition entertainment. And you will see that when you go and you look just on there on basic search, that you'll see that it'll list certain people with names or phrases, and it doesn't have exclusive rights to that. So you know that if someone isn't using it in that order, you really can't go after them. So even though it was close to what I was doing, it still wasn't enough for me to say, hey, this is what I'm gonna keep doing. Now, with the patent laws, there's no way that you can patent an act of nature and people will try it. So make sure that whatever you're doing alters something, like I said, either chemically, advances something that's new, or it's a new way of doing something. This is why these things became successful, and this is why you're able to patent it a lot easier. But something else that I should probably mention before I continue with patents and go back to trademarks is if you have a unique name, it is a lot easier to trademark it. Just remember, if you're doing something in a different language, you can't just say you have exclusive rights to that particular word for that different language. If it's in French and you're trying to register it, because that's not the way it works. However, the way you defined it, when you use it, that will determine whether you get to have rights to it in its trademark. But if you have a made up name, like for instance, Yahoo didn't exist until they just made up Yahoo, right? They had the drink, but it wasn't a search engine. So they were able to trademark no problem, because there's no competition or no one close to it to say, hey, that looks like something that I have already and that I've been using. So when you go back now to patents, same thing, same concept. As long as you can show scientifically that you've changed whatever it is, you shouldn't have a problem. But just because you thought of it or it's something that happens in nature, that does not mean that you can patent it. And copyrights, you can protect all the stuff that you write down in your life. You actually automatically have a copyright if you happen to have a date listed that shows either in your metadata or something, right? So let's say you do something in Microsoft Word and you took a note of it and you wrote it down. It already copies in the back the date that you did it, but let's just say you put the date on it. When you do that, that already gives you a general copyright over it, so that if you need to prove that you were doing this thing beforehand without physically registering it, you can. So it's always good to note your ideas and any books you're working on or anything of that nature, just so that you have it. I know a lot of people use it in their phone, but things in your phones can get lost. So make sure you back up to the backup to the backup. So back up to your cloud, still save it on something, have it everywhere, send it to a separate email, do what you need to do so that you have these things in place that show how you've been using the stuff that you thought of and worked on your own. So there are different types of trademarks. And what's interesting is people don't really speak about this. I've seen some people in the legal field not really speak about it. And I think part of it is those people in the legal field, and I need you to pay close attention to what I'm saying. If at some point you're going to hire a lawyer and they don't use the term intellectual property at all and say they focus on a particular thing, understand that being a lawyer is just like being a doctor. They have to train under someone. So just because you're a lawyer and you have the license and you can file on people's behalf does not mean that you really understand what it is you're filing and the whole point of having a trademark, service mark, etc. So pay attention to that. If at no point in their posts, the ones on social media, they don't say intellectual property, they're all lawyers that do IP, they don't necessarily do patents. Some may not even do copyrights, but they will always say that they are an intellectual property lawyer with like a focus on trademarks, or they just work on trademarks and patents, so they just work on patents. I want you to keep that in mind because I see a lot of people popping up on a trend right now, and it takes advantage of people trying to do the things that they're trying to do, and they're trying to do it right, and they want the help. And a matter of fact, there is a IP lawyer who is now studying under the tutelage to do criminal law that I spoke with a couple of weeks ago. And he said that that bothered him quite a bit because it took him a long time before he felt okay doing trademarks for people when it had to do with difficult trademarks, but he still had a mentor that had been doing it for over 15 years. But he said he sees a lot of people coming up now and they're just saying this is what they do, and they're charging a lot of money to push paper. And he said that that wasn't fair to them. So then he started focusing on criminal law. So now he's training under somebody under criminal law. Like, so if someone's already doing criminal law and then they start doing IP, and then they can't tell you what other person helped them or what other lawyer organization or where they helped them to understand, then you need to pay attention to that. And the reason he's doing criminal is so he can prosecute people as well who do these things with trademarks and infringing on people's trademarks. But on top of that, the corporate end of that, and he enjoys making things right for people. So we had a whole conversation about that. And so he's someone that I absolutely trust. I hope that he stays doing IP, but we'll see because now he's in this criminal life. So yes, can you get help from lawyers? Absolutely. Will they help you understand the differences in this? Not all of them talk about it. So a trademark, you see everybody use a TM. There are people who will just put a TM next to something. That doesn't mean anything. That doesn't mean that they necessarily register it. What I would do, and what I do now, because I'm like the FBI, the CIA, and everybody else, when I see a TM next to somebody's name, I head right on over to uspto.gov and go search, because I want to know if they're actually in the system. TM simply means that you made it through the first process, process of registering your trademark. And for some people, because it's so recognized, they still use it after their trademark is registered. So that's what you see the TM for. But some people will use it because they think it provides a general protection for them just because they have it. The other issue is just flinging that word around for no reason. And then they want to go after people and do cease and desist, but you don't have anything to back it up. Again, because you used it first, that gives you proof to say you used it first. But if someone registers it before you and you're using this symbol, then I mean, what is that going to do for you? A service mark actually exists, meaning you provide a service, but you all have probably never seen the word SM or the initials SM next to anybody's mark. You've probably just seen TM or the R for registered. Now, what people don't realize is it will ask you, are you doing a word mark, which is your words that recognize your service, or your trade, your brand, right? And when you click on that within the form that they give you, that's what it's referencing, because you can trademark an image, which you see people do. However, it is my suggestion to you that you trademark the word or the terms of words that are recognized for your brand versus the image. Again, this is not legal advice. This is general advice. And that is because if you so choose to change your logo, it won't matter because you have the words protected. So if the words are used in any which way in the form of however you register it, you will still be protected. Versus if you change your logo, then you need to go re-register your new logo in order to keep it protected. So that's a tidbit of a little bit of extra spice of advice for you when it comes to that. The R that you see is the R that you see mostly on packages. Very rarely will you see it online or on the internet, but people still use it. You may see it on some websites, and that's the part that says you made it through the whole process. Now, to make it through the process, it takes a year typically. But when I called the USPTO office a couple of weeks ago to clarify the length of time as I was registering new trademarks and I was helping someone else register theirs, they explained because of the pandemic, everything has just gone haywire and they're so backed up. So they hired a whole bunch of lawyers before the end of the year so that they could get through it. They've had the most trademarks filed in history that they've had. So when that was explained to me, I was like, okay, so what's the new turnaround time? The new turnaround time after you submit your paperwork, you get that TM because you made it through the system to say that this is registrable, right? But then they still assign you a lawyer. They assign you a lawyer that can answer questions for you, that will tell you what actions need to be taken if you need to change something or a definition. What they can't do is give you legal advice. Now, they may word it a certain way so that you understand it, but they are there to help and they're not there just to strike you down and say, no, you can't do this. So be aware of that. When she said that, she said now it takes about a year and a half before you get assigned a lawyer. So I want y'all to hear me get a year and a half, went from 6 months to a year and a half. So when you make it through the first process, you can definitely use that TM next to your name forever and ever until you go through the final process with the lawyer. What the lawyers do on that end is they too will research to make sure that your mark isn't being used by someone else or wasn't established and used by someone else. This is why doing your own research is very, very important at the beginning. And then they will tell you if you need to add anything. They'll let you know if they're going to change something in your definition because they don't understand why you would put those words together that way. And then that's it. So what you end up when you hire a lawyer, paying for a lawyer to do, that lawyer still has to engage with the lawyer at the USPTO office. And so you're hiring them to respond to actions. That's what they call them. Those little letters you get that say, hey, this is wrong, or can you edit this, or we remove this, say that you accept this. Just know that when I started, those actions were mailed. And now these actions are via the email address that you use in the system. So you will get an email from your designated lawyer assigned to you that will ask you questions, will clarify things for you, will help you with the rest of the process and tell you what they need. Just keep in mind that you are not to get overwhelmed. It's no different than answering anything else that you get. And if your definition you don't feel is up to par, or you feel that the change is too much, just simply look at writing it out again and trying to change it a little bit. But if you just pick the ones that already exist, you will be good to go. Now, the state versus federal trademark. We talked about this a little bit, and I didn't get into it a little earlier on because I wanted to discuss more about this TM mark. And that's when I was mentioning it and I paused earlier, this is why. The same way you register your business for your state, right? You go to the Secretary of State, there's also the option to be able to register a trademark. The trademark would be for your state and or for your county. So that trademark only protects you within your state. It doesn't protect you federally, and it doesn't protect you federally with the partner countries that we partner with in regards to, and we, by we, I mean the United States partners with in regards to federal trademarking. So be aware of that. People think they get it. They go, oh, I only paid $25. I got my trademark. It was so easy. And it's for their state. What happened was you look it up in your state, see if anybody has your business. They don't have your business. When you go in that same area where you registered your business, you can file for your trademark. It's just in the state. Now, a case of this that I spoke about in an earlier class is Burger King. In Burger King in the Midwest somewhere, I can never ever remember what state that is, but there's a Burger King that existed before the Burger King that you know now. And that Burger King, because they were so like, wait, these people are taking our stuff and they're all opening businesses all over the place, they took them to court. And when they took them to court, because they couldn't show that they registered federally to protect their name, Burger King, they only won for their particular state and or county. So in that particular county, you will find, even to this day, that there is no Burger King like the Burger King that we know that exists in that state or county, because that Burger King that existed before them had established that they were already established there, but they couldn't stop them from doing it all over the country or all over the world for that matter, because they didn't have federal protections. So that type of protection, and I'm going to put that in air quotes, is the exact thing that happens if you just register for a state trademark. So be mindful that you don't want to just do state, you want to do federal. And it's the only one that will also protect you with partner countries. There's a new regulation that came out recently, because you know China is good for copying some things over and over again. I've noticed an uptake in Chinese registrations for marks lately, quite a few, because I've been in the system and looking at it. Just know that there are some partnership things going. I don't know how that's going to be affected with what's going on in the news now, where now they just can't take over and copy stuff and do it in their country the way that they are. But just know that Asia has its own registered guidance for their government. So if you want to be protected in Asia, you're going to have to go register over there, and you will need an Asian lawyer to do so. But Australia and some of the European companies that we have partnerships with, it's some of the same thing. Now, how long does a trademark last? I already told you that it lasts for 10 years, and then you have to renew and show that you're using it in commerce. After that, another 10 years goes by, you do it all over again. So people with multiple trademarks, just imagine what their fees look like when they're going up to show this one more time. Now, something that you need to also write down is, I told you earlier on to define your business and what your business does. And when you define that, it makes everything easier. So classifications, you've heard me refer to classifications as categories. It makes it easier for me to do this when I'm teaching people, because they don't speak in federal government talk like I'm used to doing. And federal government talk calls things classifications. There are codes, national codes, NCIS codes, which are the same thing. So if you're used to doing government contracting or looking for grants or filing for those things, you will be aware of what those codes are. I happen to list the ones here that are for the baking industry, for people like designing sugars, food, even edible papers, stands, all of that stuff. Those are considered goods. And these are the numbers associated with the USPTO.gov office that you can use for that. Services, some of these services you will notice have multiple definitions under them. The same thing for the goods, but this is for those who are like, I'm a baker and I'm providing baking services for people, or I'm teaching this to people. Some of these same classes work for marketing and business as well. So just pay close attention to them and make sure you Google them if you have to, or look them up directly on the USPTO.gov site to get the definitions of what these are. Now, let's say you do multiple things within this particular class. As long as the number is the same, your price will be the same. Right now, if you use the definitions that exist within the USPTO, your price is $250 per class. I'm only going to focus on this and not the one where you write your own definition, because a lot of these classes allow you to expand on your definition. They make it open-ended so that you can write more to it without having to pay the extra cost to define what it is that you do. If you are doing 30, let's say you do class 35. In class 35, you wrote a definition for something and you're like, oh, this definition looks like something I do. And you go under and you see another thing and it says the number 35 next to it. And you're like, oh, I do this too. You can click on that and you will still just pay $250. Now, if you look at a number and the number changes and it's like 40, and you're like, I do this too, let me add this, and it has multiple things under it for class 40. You may click on that too, but now you have two classes that fall under 35, and then classes or definitions that fall under 40. Because you did that, that's $250 per class. Even though it has multiple under it, you're still just paying $250. That's now $500 that you're paying to register your mark. So if you have goods and you know the goods don't fall under services, and you add that, add another $250, so that I'm clear on how much you're paying for it. What's interesting is there are companies out there charging you $200, I think it was $299 or $289, something crazy, and they don't even help you with this part. They have you fill out the form the same way that you would on the USPTO.gov site, and they charge you for that. And there's a reason for this, that it's happening now. There used to be companies that would file it for you for an extra fee, but as of January 8th, that can no longer happen. So at the time of this recording, January 8th, 2022, you cannot file for other people their trademark if you are not a lawyer. Even people that work in the legal field, and let's say they're a paralegal, they have to have a lawyer register for them to be able to speak on their behalf for their client. Now you have to register yourself, and the government has gone away from, and this is the government in general, from just people registering in general, but now you have to use ID.me, ID.me is what they're using, where you put up your license or any state or federal issued ID in order to verify who you are. You give them other information that they ask for. They want to see your selfie with your ID now, because they want to make sure it's you working on it. So you can register yourself, a lawyer can register you. That's it, nobody else. So all of these extra companies that were doing it, it became a problem. I have a client now who's using me, who actually became part of that, had been listening to me speak about this on audio apps and all of this stuff, and all the time was going through an issue in which a company that they paid for went and registered them and then tried to charge them more to continue the registration when they only set a certain fee on top of the amount they were putting in, and they did the bare minimum. They clicked on a class, hit submit, they did something else wrong in the paperwork, and now that individual is working with me to get it clarified because the USPTO rejected the registration. And the reason it was rejected is because it was found that this company, along with other companies, were doing a lot of fraud. They would hold on, change the emails and stuff, try to keep the person from having access to their application in order to get them to pay more money when they charge them a low fee, a very low fee at the beginning. And so now we're going through the process where I'm like, I'm going to have you do it yourself, and this is how you're going to do it. So that's what's happening now. So to crack down on all of this fraud that's been occurring, especially the uptick in it due to our current pandemic situation, that's why you can only do it yourself, or you have to do it through a lawyer that's licensed. And let me be clear with that too, because there's some people that are like, oh, I can do it for you, and they're no longer really practicing law. They no longer have their license, but they're not allowing that anymore. And I've already explained to you how that's being verified right now. So that being said, because I was asked this so many times if I would do one-on-ones, and at one point I did, but it takes a very long time to do a one-on-one when you're doing a live registration. I am going to do a group because I've been asked, and I'll have to send an email to let you know when. For those of you all that are interested, you have my email for courses and classes right now. Just send a response and let me know. I'm going to do it on a Saturday because it's going to take a while. I'm also going to make sure that some homework is done way before we get started on the filing process as part of what's going on. And I'm actually finishing a book now because my business partners have been pushing the heck out of me. They were like, you need to write a book and make it easy. So I'm going to write a book, make it as easy as possible, and it will not be super, super long. Like, I don't know why people think, y'all are about to crack. I don't know why people think that people want to read all the stuff that they copied and pasted from the USPTO.gov site and then say I wrote a book. No shade, just saying. And I'm not about that life. I just want to make it easier in a way that people can understand and functional for people, because reading can be boring and people don't like to read. So trying to streamline a process for people so that they don't have a fear of doing that themselves, then they'll be able to do it later. So I teach you to fish, then you can do anything you need to do when it comes to your property. That being said, I hope that you found this beneficial. I'm going to open it up to questions. And if you aren't already following me on my social medias, do so. I would appreciate it because I'll put out stuff there quicker than anywhere else, and we can keep in contact outside of my email list. All right. So if you have questions now, what I'll go ahead and do is I will turn off the recording so that you can have your privacy and I can answer questions for you.